In terms of the big picture, when you combine this decision with the Shelby County decision in 2013, which said the federal oversight provisions of the Voting Rights Act are essentially defunct. The Voting Rights Act today appears to be close to a dead letter. It's close to be irrelevant. So, when these states pass all these laws, as they have been after the 2020 election, the claim has been, well, Democrats, African Americans, people of color affected by these decisions can just go to court and challenge them. As a result of what the Supreme Court has done, it's going to be next to impossible for the federal courts to rule to overturn these laws. So the only way the Voting Rights Act is going to become a real serious force in American life again is if Congress amends the law. And as long as the filibuster remains in place, even 50 Democrats plus Vice President Harris will not be able to amend the law. So the action really now belongs to Congress, because the only way the Voting Rights Act is going to become relevant again is if Congress amends the law, which at the moment it looks like they're not going to do.
Yeah, and so that could take a lot of time, and we already know that at least 14 states have passed laws that critics say do tighten voting rules. So when you talk about this Arizona decision really zeroes in on effect, do you believe that if there are going to be court challenges against any number of those new laws in those 14 states, that they will have to pursue it from an intent point of view in order to be successful?
Well, Frederica, that's a very highly relevant question, because just last week, the Department of Justice challenged the new law in Georgia, the new vote restrictions in Georgia, and I think they knew this was coming from the Supreme Court, so they did not use the part of the law about discriminatory effects. They used the part of the law that says laws cannot be passed with discriminatory intent. But again, it's important to point out the Supreme Court has narrowed the definition of intent as well, made it harder to prove discriminatory intent. And if the message, the broader message of the Shelby County case 8 years ago, this case today, is that the Supreme Court is going to make it hard to use the Voting Rights Act. So the chances of success of